a 40-year assessment of UNCLOS-created institutions, success or failure. Panel 1 will be the only portion of the UNCLOS at 40 conference that will feature video recordings from our distinguished speakers who are in locations where time is either very early or very late in the day. I am pleased to introduce our moderator for this session, Professor Laurence Boisson de Chazon, Professor of International Law at the University of Geneva School of Law and co-director of the Geneva Center for International Dispute Settlement, or CIDS. She is a recognized international law practitioner, having participated as arbitrator and counsel in various dispute settlement fora, including the ICJ, IT Loss, and the ICSID. Professor, you have the floor.
Thank you very much. So I'm very sorry not to be with you in Singapore, but it's a pleasure to moderate this first panel, and I'd like to thank the organizers for having invited me. So today we're going to discuss the convention, and Professor Oral has already used some qualifications for qualifying the convention. The Magna Carta is the most comprehensive treaty ever adopted, one of the most treaties ever adopted, and the fact that the convention also codifies a lot of segments of international law. But I think that there's also a virtue of this convention that we should discuss, which is the fact that the convention has established key institutions. And these institutions are very important because they are ensuring the good ordering and stability of the law of this regime. So if we make an assessment of the convention, we need also to discuss these institutions. And we will do so in the perspective of the conference, which is to take stock of what has happened in the last 40 years and to maybe suggest reforms if needed with respect to the functioning of these institutions. One aspect we also discuss is the fact that there are interactions among these institutions. So we have a panelist of great specialists. I'm going to introduce them by turn when they will be speaking. As it has been said, some are going to speak through video, others are on the stage. So the first speaker is Michael Lodge, who is the Secretary General of the International Seabed Authority. And you know that he's been a very active warrior in the UK and in the Pacific. If you want to know more about the bios of the presenters, the panelists, I refer you to the bios that have been distributed to the participants. So without further ado, I'm now going to give the floor to Mr. Lodge.
Greetings from Kingston, Jamaica. I wish to congratulate the director and staff of CIL for organizing this important event. The 40th anniversary of UNCLOS presents us with a great opportunity to reflect on how much has been achieved so far, as well as to look forward to shape future discussions on ocean governance and the sustainable development of the ocean and its resources. We should acknowledge first and foremost that after 40 years, UNCLOS remains the foundation for all human activity relating to the ocean and its resources, and is the best guarantee for peace and good order in the ocean. Of course, UNCLOS only entered into force in 1994, so as far as the institutions established under UNCLOS are concerned, ISA, IT Loss, and the CLCS, we are only just over 25 years of age. I'm particularly grateful to the organizers, therefore, for setting aside time in this program to make a critical assessment of the UNCLOS institutions. The history of the international law of the sea is one of a tension between exclusive jurisdiction of coastal states in areas close to the coastline and open access to natural resources in the parts of the ocean beyond national jurisdiction. The evolution of the law, even up to the present day, is fundamentally associated with advances in the technological ability of states to control the sea at ever greater distances from the shore and to utilize the natural resources it contains. Customary international law and even the 1982 Convention also reflect a strong preference for carving up the natural resources of the sea into different regulatory domains controlled by coastal states and against international regulation of these resources by international agencies. We see this exemplified in the maxim that the land dominates the sea. As a result, partition of the ocean and its resources, according to the national interests of states, became the dominant approach. In this sense, one of the great achievements of UNCLOS was to replace a plethora of conflicting and competing claims by coastal states with universally agreed limits on the territorial sea, the contiguous zone, and the exclusive economic zone, as well as clarity on the rights and duties of coastal states within those zones. Nevertheless, even from the 1970s, there was a recognition that in some situations, international rules may be necessary to ensure proper conservation and management, as well as equity over access to resources. There was also at least some recognition of the legitimate interests of developing states in equitable redistribution of wealth, even though there were fundamental disagreements over the appropriate economic measures to be used to respond to these concerns. In the end, of course, only limited recognition was given to this common heritage approach. It was decided to limit the jurisdiction of the International Seabed Authority to the mineral resources located in the seabed beyond national jurisdiction, and to give the authority no role at all in the delineation of the spatial limits of its jurisdiction. Even so, I believe this regime has achieved a great deal in terms of establishing and maintaining rule of law in the ocean. Today, I will make 5 points. First, the regime has succeeded in its objective of preventing unilateral claims to deep seabed resources. Since 1982, all claims to potential mine sites have been dealt with strictly in accordance with the provisions of Resolution 2, the 1994 Agreement, and the regulations adopted by ISA. There have been no unilateral claims, even though some key states remain outside the regime created by the Convention and the 1994 Agreement. Second, the mere fact that the Convention establishes a legal regime for the area that limits access to resources and prevents unrestrained exploitation is itself a benefit to humanity and an important contribution to peaceful maritime engagement. The fact that there is a single global regime covering more than 50% of the global seafloor helps to ensure effective and comprehensive protection of the marine environment. Through the development and implementation of a set of rules and standards governing deep sea mining and related activities, including marine scientific research in the area, it becomes possible to balance the need for resource extraction with the preservation of the marine environment. Under this single global regime, the default position is that the seabed is off limits to mining, except where expressly permitted by ISA, following a lengthy process of approval. Even at the exploration phase, the most stringent environmental regulations apply to ensure that the precautionary approach is applied and that environmental data are collected and shared with the regulator. ISA is currently in the process of establishing the most comprehensive system for environmental impact assessment and subsequent regulation for any activity taking place beyond national jurisdiction. All environmental decisions are based on the best available science and a proper application of the precautionary approach. Third, one of the core objectives of the Part 11 regime was to ensure equality of access to seabed mineral resources by both developed and developing states. The regime has been remarkably successful in meeting this objective. Today, out of 31 exploration contracts issued by ISA, 8 are held by developing countries, including 6 small island developing states. I must mention here the important contribution that was made in this regard by the Seabed Disputes Chamber of IT Loss in its advisory opinion of 2011. By clarifying the law on the responsibilities and obligations of sponsoring states, the Chamber reinforced the provisions of the Convention and opened the door to full participation by the developing countries. Certainly, more can be done, particularly in terms of capacity building, but I do not think we could have imagined in 1982 that Cook Islands, Nauru, Tonga, Singapore, Jamaica, and Kiribati would be engaged in deep-sea exploration alongside Japan, UK, Germany, and Russia. Fourth is the fact that the regime forces states to act by consensus. One criticism of all international regimes is that they can only operate with the consent of all or most states, which makes them slow and inefficient. It is true that it takes a long time to build consensus, especially when there are many conflicting interests. On the other hand, the fact that states are forced to make all efforts to reach consensus makes the ultimate regime stronger and more broadly representative of the interests of all. It also promotes regulatory stability and predictability, which are important incentives for investment and innovation. Fifth, the existence of a shared space for decision-making in relation to a common heritage resource has acted as a catalyst for innovative action on many of the underlying concerns relating to equity that were at the core of Arvid Pardo's original proposals, including capacity development and new forms of economic engagement with developing states. At the same time, we should acknowledge that much more can be done and needs to be done in terms of fulfilling the obligations to provide capacity building to developing states parties in relation to activities in the area, marine scientific research, and the development and transfer of marine technology. New developments in marine technology have the potential to transform our understanding and use of the ocean and its resources, but have the potential also to exacerbate existing inequalities if we fail to fully implement UNCLOS provisions on capacity development and benefit sharing. We also need to do a better job to link the law of the sea to the 2030 Agenda for Sustainable Development. The inclusion of SDG 14 on conservation and sustainable use of the ocean and its resources in Agenda 2030 was an important step in the right direction. But it is important also to bear in mind that the SDGs form a holistic package. They should not be viewed in isolation. The UNCLOS institutions, as well as those other organizations involved in implementing provisions of UNCLOS, should be encouraged to align their mandates and activities with the SDGs to ensure that they are delivering for all countries. In this regard, I was very pleased that an independent report issued a few months ago after extensive multi-stakeholder consultation determined that ISA makes a meaningful contribution to 12 of the 17 SDGs. So to conclude, if we are to make an assessment of the UNCLOS institutions after 40 years, I would have to say that they have been a resounding success. Certainly, as far as the area is concerned, we have seen the progressive development of a sophisticated and balanced legal regime open to equal participation by developed and developing states, anchored in the precautionary approach, transparency and equity, and fully aligned with Agenda 2030. The success of the legal regime for the area offers a concrete example of some of the mechanisms that could be replicated in future to ensure sound and careful management of global public goods. So what is important now is to reinforce our collective action to ensure that this framework is respected and reinforced, and that the institutions created for its implementation are respected and strengthened and not undermined. I bring my warmest wishes to all our friends in Singapore from the International Seabed Authority.
I'd like to thank Mr. Lodge, and it's true that we are thinking and looking at the convention and its 40 years of application, but from the outside, people are looking at the convention too for other prospects, and as Mr. Lodge has said, for the management of other public goods, and it's a good example of what could be done for other public goods. So now we're going to move to another speaker who is in the room with you. It's Professor Stuart Kay. And Professor Stuart Kay is Director and Distinguished Professor at the Australian National Centre for Ocean Resources and Security. So Professor Kay is going to be speaking of another convention, another institution that was established in the context of the convention. Professor Kay, you have the floor.
Pardon me. Thank you very much. And look, I'm delighted to be here, Your Excellencies, esteemed judges, friends and colleagues, both in Singapore and around the world. It's wonderful to be here, and I'd heartily commend everyone at CIL for being brave enough to break the mould and give us an in-person conference, albeit with many joining us from abroad. I feel a little the odd one out in relation to presentations here, because I'm conscious that I'm immediately preceding the esteemed Secretary-General of the International Seabed Authority, and I'm being followed by a judge of the International Tribunal for the Law of the Sea, who will each talk about their assessing their relevant bodies. I'm not a commissioner of the Commission on the Limits of the Continental Shelf, nor will I ever be eligible to be one, because I don't meet the criteria in the convention. Although I do count a number of former commissioners amongst my friends, and I hope after today they'll still be willing to at least communicate with me. For my part, I'm going to be talking about the Commission on the Limits of the Continental Shelf, and I'm going to, if I can get this to figure out how it works. Oh, there we go. I'm going to talk about a few things. Some are the matters that are within the Commission's control, and others are matters which the Commission has inherited by virtue of its circumstance. I'll talk a little about the application of the 10-year deadline to the Commission's work. I'll talk about the Commission's workload and the extraordinary work that it has had to do in difficult circumstances, and how it has dealt with disputes and some of the costs entailed by states making submissions to the Commission. And then I'll draw this together in some conclusions. Now, the 10-year deadline should be known to many of you. It pertains to provisions in the annex to the Convention dealing with the Commission that provides states making submissions to areas of continental shelf beyond 200 nautical miles need to do so within 10 years of the entry into force of the Convention for the particular state. Now, this proved to be a generous amount of time in theory. In practice, though, it proved a little much for many states. And it was pretty evident after about 5 or so years that states were going to struggle with the 10-year deadline, particularly when the initial 10-year deadline for so many states, more than 80, was going to be the 16th of November 2004. That seemed a little wishful that states would make it by that deadline. In fact, only 3 states managed to make submissions before that date had passed. So states worked together and decided that the 10-year deadline would not be calculated from the date of entry into force for the states, but rather would be the 10 years from the adoption of the Legal and Technical Committee's guidelines for the CLCS, and or 10 years from the date in which they became a party, whichever was the latter. Now, this gave states a date, typically for most, in the middle of May in 2009. But again, this was going to be challenging. The data that states have to collect under the convention is quite difficult, particularly the sediment data for areas of continental shelf, and specialist equipment, special ships needed to be procured. And so the deadline was still going to be challenging. One way around this was the state parties to agree that other mechanisms could be used. Now, as international lawyers, this was something that gives one a little concern because this wasn't in the convention, but nevertheless, all the state parties worked together, and I think the solutions they came up with showed some degree of innovation. They indicated that, first of all, that a partial submission could be made by a state to the Commission, or a state could lodge a preliminary information, giving further notice that it would be making a claim a little down the track. Now, the mechanism of preliminary information had all the hallmarks of something which states could exploit if they didn't really want to do any work to make their submission, because there were no guidelines as to what the preliminary information should say. It should be adequate to describe what would occur, but not go any further. And some states lodged voluminous preliminary information. I think the record was held by the French Polynesia submission that was over 2,000 pages long. And the record at the other end of the scale was the Union of the Comore Islands, who managed a one-page preliminary information submission. And pretty much everything in between. Now, the proof of the pudding of this approach, I think, is in how many states have actually followed up, have taken the process seriously. And I must confess, before I embarked upon this preparations for this presentation, I was very sceptical. I thought states will probably get out of doing work if they can do so. But in fact, the reverse is true. Of the 46 examples of preliminary information that have been lodged, all but 3 were made in 2009, with the original deadline high in mind. And all but 15 of those original preliminary informations have been followed up with submissions. 2 of which were partial submissions, but the remainder were all full submissions. And this suggests states took their obligations very seriously, and the process has worked. It has allowed states to move forward. So this is a great success. It also is something that avoided the imposing additional work on the Commission, and I'll say more about the Commission's work in a moment. The preliminary information also led to the joining of states together, making joint submissions. A whole series of individual preliminary informations were lodged by states, but the states that are visible on the screen ended up making joint submissions together, and I think this is also a marvellous result. I've mentioned already workload, and the Commission is provided for with 21 commissioners who are nominated by their governments. Pre-COVID, they were working up to 21 weeks a year in New York and were not paid under UN salaries, but being paid by their governments who nominated them. As a result, their remunerations varied considerably. They did, however, work assiduously and well. I'm going to hurtle through a whole pile of submissions, and you can see the recommendations adopted for these submissions. You can visit this on the UNCLOS website if you wish to look at it yourself. But you can see they've been very busy. You can also see there was an extraordinary profusion of submissions around the second week of May in 2009 in a desperate attempt to make the deadline. And ultimately, we can see the Commission has still got a way to go in terms of catching up with that extraordinary volume of submissions that were made. If we get through, we can see they've still been coming regularly, thick and fast since 2009. And the total number of submissions as at last week was 90, together with some additional aspects of existing submissions. So it's quite a sizable amount of work. The Commission itself has been labouring assiduously but fruitlessly in trying to diminish the pile of submissions it received in 2009. The diagram on the screen shows you in red the submissions that were received each year, and in blue the recommendations which the Commission was able to make. And you'll see, apart from a little blip at the very beginning, it's only in 2016 has the Commission ever been able to produce more recommendations than it received in submissions in a given year. As a result, the number of outstanding submissions that the Commission has at the moment is represented by this cumulative graph. And it doesn't take a rocket scientist to work out the Commission has an awful lot of work to do. Quite extraordinary. And to that extent, I feel they've been a little let down. The convention envisaged that it would be a temporary body and it would be able to do its work and be done. But the poor Commission has been labouring away, and the volume of work has proven to be far greater than anyone could have anticipated. At their present rate, assuming the rate of submissions continues at a 3-year moving average, and we've all got very good at moving averages as a result of COVID, it will take 54 years for the Commission to diminish all of its outstanding submissions, and that includes the ones that are blocked because of disputes. If they were to never receive another submission as of today, it would still take them 15 years at their present rate to clear it out. Now, that's most unfortunate for the Commission. It's not to suggest they've let the side down. For people who are not paid by the UN to be working 21 weeks a year is pretty extraordinary. But nevertheless, they have much, much work to do. Within that work, they've had to cope with disputes. And the rules for dealing with disputes are set down in the rules of procedure of the Commission. And basically, they indicate that the Commission should be able to park a dispute to ensure that it doesn't cause any difficulty. This is because it was envisaged that there would be disputes involving sovereignty or disputes in relation to delimitation. Less evident in the rules of procedure were the possibility of a dispute based on the law of the sea practice of a given state, that a state might have excessive territorial sea baselines from which part of the submission might be calculated, or might assume that its maritime jurisdiction from a particular feature qualified for a continental shelf when the feature perhaps was questionable. It also seemed to assume in the rules of procedure that adjacent states would be the ones who would be doing this, but other states could be interested where excessive baselines or status of features were an issue. And some of the claims that have been made could be viewed as ambit claims, designed to emphasise a dispute rather than to resolve matters for a submission. To give you examples of how this has perplexed the Commission, one of the early submissions involved a submission by Brazil, and the United States lodged a note verbale, the way in which a state expresses concern or indicates a dispute to the Commission with respect to the status of a particular submarine feature. Now, the Commission decided not to deal with this note verbale to prevent it from considering the submission on the basis that the United States was not an adjacent state and therefore was not one that needed to be dealt with. This situation, however, was approached slightly differently by the Commission in 2009 when it faced notes verbale from the Republic of Korea and China concerning a Japanese submission which in part included a continental shelf generated by Japan's southernmost territory, Okinawa, which is famously very, very small, and Japan is of the view it generates a shelf, and China and the Republic of Korea were of the view that it would not. The Commission, rather than backtrack and suggest that their approach with respect to Brazil was incorrect, decided to receive in a subcommission the Japanese submission, but then not to take it any further. And since then, the Commission has, when a dispute has arisen, regardless of the geographical location of the state concerned, has taken this approach not to proceed. And I think this is probably a safer approach than the approach as initially considered. However, the disputes that the provisions dealing with areas of shelf pop up all over the world, and states that otherwise might not have much to dispute have ended up with overlapping claims and the potential for much dispute. On this map, you can see the two sovereignty disputed features that exist in the entirety of that map. They are very small volcanic outcrops that are located there. One is called Matthew and the other is called Hunter Island. Yet you can see the areas of overlapping shelf that their existence has given rise to, where numerous states have managed to lodge claims. These ones are going to be dealt with for the most part by the Commission. There are a couple that are ruled out, but everywhere where you can see cross-hatching is an area of dispute. And so in an area of the South Pacific largely devoid of dispute, we suddenly have a whole host of them, which is unfortunate and certainly not the Commission's fault. There are also areas, though, where states have lodged quite, I won't say aggressive, that would be the incorrect word, enthusiastic claims to continental shelf. This, for example, is the extended continental shelf asserted by the People's Republic of China in the vicinity of the Okinawa Trench, and very, very close to Japanese territory, you can see. And there's the submission of the Republic of Korea, also very close to Japanese territory. One imagines that it was always rather likely that there would be notes verbal lodged with respect to these, and that's exactly what has occurred, and it will mean the Commission is unlikely to deal with these anytime soon. There's also the most I'm sure note verbal shouldn't be used as a verb, but the most note verbal submission of all time is this one in the middle of the South China Sea, which was lodged by Malaysia at the very end of 2019. 2020, my sincere apologies. In any case, not that long ago. This one has been the subject of notes verbal by China, the Philippines, and a host of states who are nowhere near the geographical location of this line. But you can see that it was unlikely that this one was also going to not lead to some consideration of disputes and therefore be unconsidered. A final point I'll make with the brief time left to me will be in relation to costs. And this is one thing where I think the Commission has set a bar very high and as a result has cost states an awful lot of money. The cost of collecting data for the extended continental shelf can be very, very high. And the use of desktop studies to assist in this process would have been of great advantage to many states. But it was largely rendered unavailable to them. And this is because of a provision tucked away in the technical guidelines of the Commission. And if we pull out the relevant part, which I can zoom into, Rule 4.2.6, notes that some sources of evidence available, such as satellite, allometry-derived bathymetric data, will not be regarded as admissible. Now, what is this data? Well, this is the data you can download for free from the from NOAA in the United States. It's a topo data. The Topo project has given increasingly accurate bathymetric data of areas of seabed depth around the world. If you have a spare 7 terabytes in your computer, you can download it yourself. It will take several hours, but you can do so, and do so at no cost. But the Commission has effectively said, well, no, we don't think this data is good enough. I'm told by those who know that the data is not so bad. And so having states go out and try to collect this is certainly a substantial expense, and one which in hindsight I think is harsh. I can understand why the Commission sets a high standard, but nevertheless it has cost an awful lot of money and been responsible for something of the delay that was necessary with the 10-year deadline. As well, the requirement for the sediment thickness rule is one which sounded a great idea, I'm sure, in 1982 for everyone, a marvellous compromise, but in all of the submissions that have been made, just under 15% of the submissions pertain to areas related to the sediment thickness rule. It's proven not to be tremendously useful for most states most of the time. And whether they could have gotten by without it or not is a moot point, but certainly the amount of expense and time that was necessary for it has been troubling. And that's a shame. Again, that, however, is not the fault of the Commission, nor is it really the fault of the delegates in their negotiations. As we've heard, they weren't to know everything. Things change, and they certainly weren't to know how thick sediment was in various parts of the continental shelf right around the world. So in conclusion, my view is that the CLCS has been given an extremely challenging task and has done so with limited resources, with some aplomb and with tremendous enthusiasm. They have done their best with a pretty ordinary hand and have done pretty good work as a result. It's perhaps ungenerous for me to say they've done a reasonable job because they inherited difficult provisions to deal with, but nevertheless they have done it well, and they are to be commended, and they have my, my sincere admiration. Thank you all so much.
Many thanks, Professor Kay, and I'm sure that there will be a lot of questions and discussions around your topic. I retain the fact that the Commission was set up as foreseen as a temporary institution, but there is nothing which is temporary, as we know. For such a huge task, the Commission is going to last for quite a long time. It's interesting that you've already touched upon the interactions with other bodies, with the Conference of the State Parties, and if there are disputes, there might also be some interactions with judicial bodies, but maybe we'll come back to that, to this issue in the discussion. So now we're going to be discussing the UNCLOS, the International Tribunal of the Law of the Sea, and we have the great pleasure to have another eminent specialist with Judge José Luis Jesus, and Judge Jesus is a member of UNCLOS. He was the president of the tribunal between 2008 and 2011, and he was also the president of the Seabed Disputes Chamber between 2014 and 2017. So now the floor is to Judge Jesus.
Mr. Chairman, I would like to start by thanking Professor Tommy Coe and Dr. Nilufer Oral for the kind invitation addressed to me to participate in this conference, commemorating the 40th anniversary of the adoption of the United Nations Convention on the Law of the Sea, organized by the NUS Center for International Law. My salute to you, Mr. Chairman, and the other members of the panel on UNCLOS. Mr. Chairman, ladies and gentlemen, today we celebrate the adoption of the Law of the Sea Convention in 1982 in New York, undoubtedly a landmark in the development of international law. Being myself a member of the delegation of my country to the third UNCLOS, I was lucky to have witnessed personally the historical and unique moment when delegations cast their vote, adopting the convention almost unanimously, thus crystallizing its text and sealing off several years of hard negotiations. The UN conference room where the adoption of the convention was being put to a vote was full of people as never before, reflecting the historical importance of the occasion. The last-minute issues that were raised by delegations amid the nervousness of the moment were skillfully solved by the president of the third conference, Ambassador Tommy Coe, to whom I would like to pay my sincere tribute for the great leadership he provided to the Law of the Sea Conference in its final years, for his hard work that made it possible to find common ground on a number of difficult negotiating issues, and especially for the way he conducted that particular meeting of the conference on the day of the adoption of the convention, demonstrating not only his usual great leadership, but also great courage in putting the convention to a vote that day, thus avoiding the erosion of the negotiated text. Since then, the convention has been hailed as the Constitution of the Oceans, in that it sets up the basic framework for the ocean's governance and lays out the guiding principles and regimes for the peaceful uses of the oceans and their resources, at the same time that it outlines a general regime for the protection of the marine environment. The Convention is in fact a structural treaty in that it is a major pillar upon which the international law of the sea rests, providing the necessary stable framework foundation for further development in the field as the world moves on. 40 years after its adoption, the overwhelming majority of states, a total of 168 states, have become parties to it, amongst them coastal and disadvantaged states, but landlocked states as well. This per se is a demonstration of great success achieved by this convention, as it has been and continues to be supported strongly, almost universally, by the community of nations. And since its entry into force, it has also been followed as a guide to the work of the international institutions and organizations when dealing with their function and activities relating to the oceans. Of course, this does not mean that some states may not have had difficulties with the legal treatment given to some of the Convention's provisions, but states understand that as the Convention is the result of a complex play of give and take that took place in the conference, it reflects a delicate balance that needs to be preserved. Based on the observations of the activities in the oceans, it is safe to say that the Convention, in 40 years since its adoption, has undoubtedly contributed, as stated in its preamble, to the strengthening of peace, security, cooperation, and friendly relations among all nations, and it has provided a stable legal order for the seas and oceans. The three institutions created by the Convention have also done their part in the process, as they have taken important strides in the implementation of their functions, thus contributing to making the Convention a workable legal regime. These are the International Seabed Authority, to assist in the implementation of the provisions of the seabed regime, the Commission on the Outer Limit of the Continental Shelf, to assist coastal states in outlining their outer limit of the continental shelf beyond 200 miles, and the International Tribunal for the Law of the Sea, to adjudicate disputes between states that may arise out of the interpretation or application of the Convention. In some cases, it may take more time than previously envisaged by the Convention for some of these institutions to fully implement their functions. In the case of UNCLOS, whose work I've been given the honor to comment upon in this panel, my view is that its work, as designed by the Convention, is in a good track. I will attempt to assess its judicial work, which per se is an important evidence of the acceptance by all states of the legal regime contained in the Convention. Some of the things I am about to say may have been said by UNCLOS President in his keynote speech. Forgive me for possible overlapping. Mr. Chairman, Part 15 and related provisions and annexes of the Convention, which contain the dispute settlement system, are being implemented by courts and tribunals referred to in Article 287, Annex 7. Arbitral tribunals are often constituted to entertain specific disputes, and the two permanent courts, including UNCLOS, are also playing their role in dispute resolution within the framework of this system. From this perspective, this settlement system has proven to be workable, and recourse to it by states parties to resolve their disputes arising from the interpretation or application of the Convention indicates that those states, in general, are abiding by the Convention. In my view, the innovative compulsory jurisdiction built in the Convention, which gives the state party to a dispute the possibility to submit a case to a court or tribunal without the agreement of the other party to the dispute, has been the pivotal element of the settlement system in maintaining the integrity of the Convention, even when there are several disputes that may not fall under the compulsory procedure set forth in Section 2 of Part 15. There remains a great number of potential disputes that fall within that compulsory procedure. Indeed, the compulsory mechanism made it possible for the filing of all the cases that so far have been submitted to Annex 7 arbitrations. In the case of UNCLOS, the overwhelming majority of the disputes submitted to it for resolution were based directly or indirectly on the compulsory mechanism. All the cases of prompt release of vessels and crew, and all the cases of provisional measures filed under Article 290, paragraph 5 of the Convention, pending the constitution of an Annex 7 arbitral tribunal, were submitted to UNCLOS on the basis of the compulsory mechanism. Likewise, most of the cases on the merits submitted to UNCLOS came as a result of transfer to it of disputes previously submitted to Annex 7 arbitral tribunals through the compulsory mechanism. This compulsory mechanism is what, in my view, has maintained the vitality of the Convention dispute settlement system, and by implication has ensured the integrity of the delicate balance of states' rights and interests translated into the provisions of the Convention. Mr. Chairman, a great deal can be said about the role of UNCLOS in the interpretation and application of the Convention in the context of the disputes submitted to it for resolution. Due to time constraints, I will confine my comments to give a brief assessment of its judicial work since 1996, when it officially started its functions, and I will highlight some of its contribution to international jurisprudence. Before addressing the judicial work of UNCLOS, allow me to refresh our mind about the jurisdiction of the tribunal. As is known, UNCLOS is one of 4 courts or tribunals referred to in Article 287 of the Convention, to which states may have recourse with a view to seeking the resolution of their disputes that may arise out of the interpretation or application of any provision of the Convention within the framework of its dispute settlement system. Indeed, on several occasions, several states have appeared before UNCLOS as parties to the two disputes submitted to it. Though UNCLOS jurisdiction is essentially based on the provisions of the Convention, it also comprises all matters provided for in any other agreement which confers jurisdiction on the tribunal. Additionally, it comprises disputes on the interpretation or application of any treaty or convention in force on matters covered by the Convention, if all the parties to these treaties or conventions so agree. In all the cases entertained, the jurisdiction of UNCLOS has been based on provisions of the Convention. In one case, however, case 21, a request for an advisory opinion, the jurisdiction of the tribunal was based on an international agreement related to the purposes of the Convention, which specifically conferred jurisdiction on UNCLOS by reference to Article 21 of its statute. A brief rundown of these cases shows that of the 29 cases received, 27 are contentious cases, and the remaining 2 are advisory opinions. Of the 27 contentious cases, 3 were discontinued at the request of the disputant states after reaching an out-of-court agreement through bilateral negotiations. 8 of them were cases of urgent proceedings under Article 292 on prompt release, involving release from coastal states' detention of fishing vessels and crew for alleged violation of the coastal state fisheries legislation in the exclusive economic zone, upon the posting of a bond, the amount of which was established by UNCLOS. 9 were urgent proceedings cases on provisional measures under Article 290, paragraph 5, and 7 were cases on the merits. In the prompt release area, UNCLOS has been the only court or tribunal of those referred to in Article 287 of the Convention that received and entertained cases of prompt release. This is because the Convention gives a special treatment to UNCLOS in relation to other courts and tribunals. UNCLOS is treated as a default procedure in cases of prompt release, as it becomes the only means competent to deal with a prompt release case. If after 10 days from the arrest or detention of the fishing vessel, the 2 disputed states do not agree on a court or tribunal for the resolution of the prompt release of the detained vessel or crew. Likewise, UNCLOS has been the only means amongst international court or tribunals that has entertained cases of provisional measures under Article 290, paragraph 5 of the Convention, pending the constitution of an Annex 7 arbitration. This is another example of a preferential treatment recognized to UNCLOS by the Convention, entailing exclusive and compulsory jurisdictions. In situations where the parties to a dispute submitted to an Annex 7 arbitral tribunal do not agree within 2 weeks from the date of the request for provisional measures on a court or tribunal to deal with the request. Since the Tomimaru case in 2008, UNCLOS has not received any more cases of prompt release. I believe this may be because it has developed a quite consistent jurisprudence in the area, outlining, as it were, a roadmap that helps disputant states to solve their disputes without having recourse to UNCLOS. Concerning case on the merit received, two were discontinued, 6 have been solved, and 1 is still pending before a special chamber of the tribunal. As far as the 2 advisory opinions are concerned, one was given by the Seabed Disputes Chamber on the responsibilities and obligations of states with respect to activities in the area. This opinion is thought to have been helpful to the organs of the International Seabed Authority in the implementation of their mandate. This is so far the only case entertained by the Seabed Disputes Chamber. The other advisory opinion given by the plenum of the tribunal in case 21 dealt with the request of the West Africa Sub-Regional Fisheries Commission on behalf of the 7 member states, all parties to the convention. The jurisdiction of the tribunal in this case was based on the constituent agreement of the Sub-Regional Fisheries Commission, which has a provision that specifically confers jurisdiction to UNCLOS to consider requests for provisional measures on matters covered by the agreement. The cases entertained by UNCLOS involve developed and developing countries from all regions of the world as disputant states. They covered a wide range of issues pertaining to law of the sea, such as, among others, the protection of the marine environment, land reclamation, conservation of marine living resources, the limitation of maritime boundaries, sovereign immunity of warships, compensation for illegal arrest of vessels, responsibility and obligations of states sponsoring persons and entities with respect to activity in the area, and obligations and liability of the flag state in case of IUU fishing involving their vessels, prompt release of vessels and crew, etc. In handling these cases, UNCLOS has had an opportunity to develop a sizable jurisprudence, clarifying the interpretation and contributing to a better understanding of certain provisions of the Convention. Allow me, Mr. Chairman, to highlight some of the salient points of this jurisprudence as follows. UNCLOS has developed the concept of ship as a unit as an exception to the requirement of nationality of claims, a procedural requisite for the admissibility of a request by the tribunal. This allows UNCLOS to receive and to entertain a case at request of the flag state to cover the ship itself and all those working as crew members or all those that are interested or involved in the operation of the ship, irrespective of whether they hold or not the nationality of the flag state. On the issue of states' rights in the easy of another state, it has clarified certain aspects of the scope of Article 58 of the Convention on the rights and duties of other states, namely in respect to the bunkering of non-fishing vessels in the exclusive economic zone. It has clarified the interpretation of Article 300 of the Convention on the meaning of good faith and abuse of rights. It has also identified the flag state responsibility for illegal fishing, carried out in third states' maritime waters within the framework of an access agreement. It has also clarified the meaning of natural prolongation, referred to in Article 76 of the Convention, and stated that the concept of natural prolongation and that of continental margin are closely interrelated and refer to the same area. It addressed the issue of nationality of ships and the issue of genuine link, referred to in Article 91, paragraph 1, on 2 occasions, and brought some clarifications to the understanding of that article, which embodies a ground rule of international law. In conclusion, I would say that UNCLOS has been developing its judicial work as envisaged by the Convention. It has received 29 cases, which is a reasonable number of cases in the 26 years it has been in function. This is slightly more than 1 case per year. The number of cases received stands witness to the confidence that states parties have bestowed on the Convention and its dispute settlement system. By being active in entertaining cases as they are submitted, interpreting and applying the Convention, UNCLOS as a Convention institution is contributing to the consolidation of the dispute settlement system and the legal regime contained in the Convention. I thank you.
Many thanks, Judge Jesus, and I think it was very important to stress the importance of the dispute settlement system in the context of UNCLOS. I think it's one of the great contribution of the Convention, but also I think it was also very important to stress the contribution of the law of the sea in clarifying many issues of law of the sea, of public international law. And we may come back to the interactions of the UNCLOS with other institutions in the discussion. Now we're going to have our fourth panelist, who is known to you, Dr. Tara Davenport. She will be speaking about on some of the interactions between UNCLOS institutions. Dr. Tara Davenport is an assistant professor at National University of Singapore, and she's also a senior research associate with the Center for International Law. So, Dr. Tara Davenport, the floor is yours.
Thank you so much. Thank you. Good afternoon, everyone. I'm also delighted to be part of this distinguished panel. If Stuart is feeling like he doesn't belong, I also feel that 10 times worse. I am talking about interactions between institutions. Let me just see. Yeah. So you can see from this incomplete table about the institutional governance of the oceans. I divided it into UNCLOS created and UNCLOS delegated. And of course, we've been talking about UNCLOS created, which is IT Loss, the ISA, the Commission on the Limits of the Continental Shelf, as well as a meeting of the state parties. The CLCS and the meeting of the state parties are, of course, not institutions or international organizations as we conventionally understand them, but they are nonetheless frameworks in which governance occurs. I will be focusing on UNCLOS created institutions, but this is just to give you an example of the many different institutions that have a mandate in the oceans. So the international relations literature talks about interactions as the ability of one international institution to influence the activities of another international institution. I've taken a very broad definition of interaction, and it can take many forms. The easiest, of course, being the observers system, the exchange of information, the transfer of knowledge, joint activities such as joint working groups, and that's particularly relevant in lawmaking. And of course, there's this idea of oversight and review. And the overarching objective of such interactions are, of course, to minimize fragmentation, minimize conflict, pool resources, so to deal with common problems, ensure comprehensive coverage of issues of shared concern to make sure that nothing falls through the gaps. And of course, there are also accountability governance concerns whereby one institution can review the activities of another institution. So I'm first going to talk about the interactions between the ISA and the CLCS. As you can see here, and I think Stuart has also talked about it, the CLCS is supposed to be, it has a mandate to make final and binding recommendations on the outer limits of the continental shelf. In the Law of the Sea Convention, the area where the common heritage of mankind resources are found is defined as the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction. Therefore, of course, we have to determine the limits of national jurisdiction before we can delineate the area. This is a wonderful map of the Indo-Pacific region that my colleagues Yona Lyons and Cheng Ling have made, and I think it well illustrates the problems, or I guess the issue, or the interactions between the extended continental shelf and the area. You can see in orange, those are the outer continental shelf claims that have been made, and you can see also in orange, but closer to the sort of north of the area, where you could see the licenses that have been issued by the International Seabed Authority. In practical terms, I have read that the issue of the relationship between the area and extended continental shelf claims are not as serious because the resources, which are the subject of the common heritage of mankind principle, are far away from the limits of national jurisdiction as we understand it determined by Article 76.8. However, it is still, I would say, an issue to be discussed. The delineation of the area and hence the common heritage of mankind is still ongoing. As Stuart pointed out, there are 90 submissions and only 35 CLCS recommendations so far. I was astounded when Stuart had said that 54 years to consider the rest of the submissions. That's a very long time. There is a possibility for ISA licenses to be issued in areas where an extended continental shelf claim has been submitted but not considered by the CLCS. There is also possible for a final and binding recommendation by the CLCS to overlap with areas where CHH resources are found. There is no formal mechanism where the ISA's views on the potential impact on this common heritage of mankind can be taken into account by the CLCS when considering submissions or to challenge a particular submission in the event that it encroaches on the common heritage of mankind, or humankind as I should say. But again, the existence of Article 82, whereby coastal states are obliged to share some of the revenue that they receive from exploitation of the outer continental shelf, implies that if there were to be an extended continental shelf claim, as well as an area where there were common heritage of mankind resources, that the extended continental shelf claim would get primacy, right? Because there is already a mechanism built in the Law of the Sea Convention, whereby the ISA is to receive a share of the benefits that will go to mankind. I put here the ISA may be able to bring a claim against a coastal state, of course not the CLCS, before the SDC if it can be argued that the encroachment of common heritage of humankind areas by coastal state submissions is a violation of Part 11 of UNCLOS under Article 187B. But again, this would require quite a strained interpretation of Article 187B. The mandate given to the Seabed Disputes Chamber is over activities in the area. So therefore, it may be difficult to argue that the encroachment by coastal states is within this idea of activities in the area. Of course, the ISA may also be able to submit a request for an advisory opinion from the Seabed Disputes Chamber under Article 191 on this issue. Then I'm going to talk about the interaction between CLCS and IT Loss. Of course, the CLCS is a scientific and technical body, but as Stuart has pointed out, it has to consider several legal issues or problems. However, it has no explicit authority to participate in compulsory procedures entailing binding decisions under Part 15 of UNCLOS, or to request advisory opinions from IT Loss. I've put here two provisions. Again, if you took a very broad reading of them, maybe these provisions could be used. Section 20 of the It Loss statute says the tribunal shall be open to entities other than state parties in any case submitted pursuant to other agreement conferring jurisdiction on the tribunal, which is accepted by all the parties to a case. Again, the likelihood of this happening is probably quite unlikely. Article 138, It Loss may give an advisory opinion on a legal question if an international agreement related to the purposes of UNCLOS specifically provides for the submission to It Loss of a request for such an opinion. Again, also maybe a very unlikely scenario whereby an agreement is formed that would enable the CLCS to ask for an advisory opinion. I would like to briefly talk about the role of the meeting of states parties. Again, in 1974, the UN Secretary General stated, the conference might well consider whether some institutional means should be created whereby within the framework of this new convention, common measures should be agreed upon and taken whenever necessary so as to avoid obsolescence under changing world conditions. And I think they had in mind, of course, the 1958 Geneva Conventions, which very quickly fell out of favor. Some of the options that were considered by the negotiators were a permanent commission, a periodic conference, a review conference, and then, of course, Article 319, which is the basis for the meeting of the states parties. Article 3119 says, the UN Secretary General shall report to all state parties, the ISA, and competent international organizations on issues of a general nature that have arisen with respect to this convention. The UN Secretary General shall also convene necessary meetings of state parties in accordance with this convention. So this is sort of a very simple diagram of the role that the meeting of state parties have in relation to each of these institutions created under UNCLOS. In It Loss, of course, they are responsible for electing It Loss members, for financing It Loss. They receive the annual report of It Loss. ISA participates as observer. The Secretary General can make written or oral statements. For the CLCS, again, it's also elections of the CLCS members, and the CLCS participates as members in the meeting of states parties. The question then is, which body or which forum is appropriate to play an integrative role in oceans governance? There are two sort of differing views on the meeting of the states parties. Is it a purely budgetary and administrative role, right, to consider elections and finances, or does it have a wider role to take substantive decisions on issues relating to the implementation and development of the Law of the Sea Convention? And again, you have to also understand that the provision, Article 319, is very different from other provisions which give the authority to Conference of Parties. For example, if you look at the UNFCCC, the Conference of Parties is the supreme organ that decides upon the implementation of the convention. There is no equivalent language in the Law of the Sea Convention. And another question is, of course, then what is the role of the UN General Assembly? Of course, the UN General Assembly has played a role in the Law of the Sea much earlier than the meeting of the states parties. They are, in a way, better suited to decide on issues of the development of the Law of the Sea and the implementation of the various Law of the Sea obligations. They have a quasi-universal mandate, which includes states which would not be a party to the Law of the Sea Convention. And of course, the Secretary General prepares the annual report. There is the informal consultative process, and there's also a very useful annual omnibus resolution, which I understand is the subject of a great deal of negotiations between states. So again, this is one of the perennial questions facing the Law of the Sea. It is a challenge faced relating to the lack of an overarching institute to deal with all issues of the Law of the Sea. Indeed, even as early on in the 1950s with the International Law Commission, they considered the issue of whether there should be an international organization established to deal with all Law of the Sea issues. However, they found that that would be impractical. They would have to deal with a large range of issues. It would not have the necessary expertise. There were already many existing international institutions that were dealing with specific sectors that related to the oceans. So it was just not feasible to have this idea of an overarching institute. But of course, as we can see in the BBNJ negotiations, the lack of, or the sectoral framework of ocean governance has meant that many issues can fall through the cracks. These concerns are very relevant today, and perhaps the issue is not avoiding fragmentation, but really figuring out how do we foster coordination and cooperation between not only UNCLOS created institutions, but also all the other ocean governance regimes that exist. And I'll stop there. Thank you.
Thank you very much, Dr. Tara Davenport, for ending with this question, because as you rightly say, I think it's, we've looked and we have heard about 3 crucial institutions, but there are other institutions that should be looked at, and surely there is a need for coordination, and that surely will be a discussion during the conference that is going to take place today and tomorrow. So now we're going to have questions and discussions from the audience, and I will ask the help of the NOS staff for addressing, for highlighting the questions from the public, from the audience in Singapore.
Thank you, Professor. We will welcome questions from our in-person participants. And now I see the one hand up. Professor Schofield, there's a mic on the table. You may stay there. Yes, thank you.
Thank you very much indeed, Clive Schofield. Just a question, if I may, to my good friend and colleague, Professor Kay. Stuart, fantastic presentation. Thank you very much indeed for that. What you did highlight was, particularly in relation to the note verbals and the way in which the CLCS treated note verbals in respect of Brazil's submission versus Japan's submission, there's some evolution in approach. My question is really, have you detected an evolution in the approach of the Commission over time, particularly in light of the way in which the composition of the Commission has changed very considerably? And I think at the last elections, approximately 2/3 of the commissioners essentially changed. So there's a potential loss of institutional knowledge within the Commission, and some of the most prominent commissioners that we know and love are no longer with the Commission. So I wondered whether you detected any substantive change in how the Commission is approaching its work, and a question there of whether the work of the Commission is consistent over time. Thank you.
Well, thank you, Clive, for that question. Look, it's a fair point. I think the last election saw a changing of the guard at the Commission to an extent that there hadn't been that level of change before. This was something that a number of commentators had been afraid of, because as more and more states were having their submissions heard, the enthusiasm of those states to seek to have their nationals elected to the Commission seems to have waned. And as a result, you're left with fewer states expressing an interest, and therefore some of the commissioners have marched out and new ones have replaced them. It's hard to know whether there is a substantial difference in approach, because they haven't been very busy during COVID, relatively speaking. So the number of recommendations, which they were starting to build up a real head of steam around 2016 and 2017, has fallen off quite dramatically since the onset of COVID. And it's since then that we've seen a big change in the constitution of the Commission. So it could be that there is a change in approach. I suspect not, though. The commissioners were very eager to talk about their work at various fora around the world, and to describe in detail the processes which they would engage in. And it would be reasonably heroic for the Commission now to say, well, actually, we don't like that, we'll approach things in a different way. So I think they'll largely be consistent, but Whether that consistency can be maintained given the tremendous turnover in the Commission in recent years, I think remains to be seen.
Thank you. Are there any other questions?
We have a question from our director, Dr. Oral.
Thank you. First of all, thank you, Laurence, so much for accepting our invitation. I know it's very early in the morning for you, but we're so grateful to have you as our moderator on this panel. And I just want to also thank Stuart and Tara, and of course our other speakers who came on video. But I wanted to ask Tara a question because I'm so glad you raised the issue of SPLOS. As you rightly pointed out, when I guess it follows with the 1992 Rio Conventions and beyond, where the process was very different. As you said, the COP became the supreme body for decision-making for implementation of the convention and the UNFCCC, and there are other conventions like that. And one of the issues we face with the Law of the Sea Convention today is, as comprehensive as it is, it doesn't respond to all issues. And one of the advantages that the COP system has is the ability to, on an annual, in the case of the UNFCCC, address specific issues through decision-making process. We don't have that the way it's structured right now under SPLOS, but can we? How do you, is there a way, the way it's structured? I understand you showed the General Assembly resolution, we have Article 319. Right now it's a very administrative function. But do you see a way that could be adapted, that could be updated? I know we'll be hearing from current president of the BB&J negotiations, Rena Lee, Ambassador Rena Lee, and I'm sure that's a, you know, the COP issue is there. But I'm just thinking for the Law of the Sea Convention itself. So once again, thank you both for your excellent presentations.
Thank you so much, Nilüfer, for that great question. And I have to say that the answer to that is I'm not sure. It is interesting that it was after 1992 that the Conference of Parties were really given a lot of authority and power, and that wasn't given in relation to the Law of the Sea Convention. I think reading the reports of the meeting of the state parties, they're quite short, they are very administrative. There is some a mention of the thoughts of state parties on particular issues, but it is nothing in compared to the omnibus resolution, right, which is much longer, sort of much more comprehensive, really highlights the sort of the issues that are facing and points out the issues that should be further developed. So it seems to me that the, you know, of course, the meeting of the state parties will always play a useful role, but it seems to me that the General Assembly has really taken over that position of pushing and developing and highlighting the issues and implementation of the Law of the Sea. And I'm not sure I see a shift in that, unless, of course, state parties want to be more active. But as of now, I don't see that shift happening. But I'm very happy to listen to anyone else who has a different view. Yes.
Thank you, Tara. We have another question from the floor.
Hi, I'm Liu from Macquarie University, Sydney. Thank you, Stuart and Tara, for your fascinating presentations. I just got a question for Tara, and I find it's amazing enough when you talked about the interactions between different institutions, and as I see this as part of the discussions on regime interaction. That's fascinating enough. There are issues, overlapping issues, or conflict of issues. But I have been thinking about this for a while, and I would like to have some of your thoughts on this. So when we are talking about regime interaction, it is towards what end? Like, when you talk about that, yes, we can't have one organization to deal with all the issues, but what for? I mean, this might be a bit too general, but it's been in my mind for quite a while. Like, so I'm really curious, like, what you would, what about your thoughts? Thank you.
Thank you. That's also a great question. And of course, you're absolutely right to question we can't just have regime interaction because it sounds good for cooperation and coordination. I would say in relation to the ISA and the CLCS, it is regime interaction is probably some degree of regime interaction or coordination, cooperation is necessary to avoid conflicts, right? Whereas, in terms of the outer continental shelf claims and the area and this idea of encroachment onto the common heritage of mankind. And I believe these issues have been raised in the CLCS submissions, the concerns of states that these extended claims to national jurisdiction are really encroaching on the common heritage of mankind, which is supposed to be for the international community. So in that particular respect, it's I would say, not a minor problem, but it's an issue of avoidance of conflicts. But in other areas, I mean, we can see with the pandemic how it was very necessary for the international organizations there the WHO, the IMO, the ILO, to all coordinate and cooperate with each other in order to develop standards to solve this problem. So I do think that, in certain specific cases, in many cases, in fact, and I think my colleague Yona is also going to be talking about this in relation to marine plastics, there are some issues which cover the mandate of many organizations, and therefore you need that sort of coordination and cooperation to deal with that. Thank you.
Thank you, Tara. Do you have any further questions from the floor?
So maybe I could ask a question to Professor Kay before we give the floor to the audience, the virtual audience. I very much enjoyed this presentation as the others, and he ended with the fact that the Commission is facing a daunting task, a challenging task, and it has limited resources. And I was, and in addition, you stressed, Professor Kay, that there are a lot of disputes which put to a halt the work of the Commission. So I was just wondering, what are your views with respect to the future to address these challenges?
Oh, look, thank you. It's a very thoughtful question. Look, I'm of the view that there's good news on the way. I really think that for a while there, states were very keen to throw out the note verbale and block consideration by the Commission. I think that's diminishing over time. There's a far greater willingness of states to allow the Commission to consider data while reserving their rights. That map of the South Pacific I showed you, almost all of the cross-hatched areas that overlap are being considered or have been considered by the Commission, because the states concerned have said, look, we don't want to cause issues for our neighbours. We don't want them to have laboured to create a submission to no purpose, so therefore we'll reserve our rights, as we're entitled to do, but we'll allow the Commission to consider it. And that's happening more and more. Whereas in the past, I think back in around 2009, 2010, 2011, the practice was you lodged a note verbale and you blocked, and it didn't matter what implications that had for your neighbour. And that suggests to me that there's a reasonably constructive approach around these issues by states, that they're willing to allow their neighbour the opportunity to go forward. And to that extent, I think that's encouraging. That suggests that states view the Commission as having a positive role and wanting to do its job. And whilst there are a number of submissions that are blocked, there are 9 that are completely blocked and are unlikely to move. There are also instances of ones that have been blocked that have been either partially reduced or the blockage has been completely removed, which I don't think was expected a decade or more ago. So I think there are good things happening, and I think that's encouraging, and the Commission is being reasonably sympathetic to these issues as well.
Thank you.
We have
So-
one question from the floor, Professor. Professor Tomiko.
Thank you. I'd like to ask Stuart a number of questions. The CLCS is faced with a very big load of cases that they have not cleared. And I'm wondering whether we can expedite the process if we were to pay the commissioners, if we were to request them to work for more than 21 weeks a year, if we consider the possibility of dividing the 23 commissioners into 3 sub-commissions, and how can we speed up the clearance of the backlog?
Look, again, very good questions, and I think Ambassador Coe's questions have all been suggested as possible ways forward to try to assist the Commission in clearing its backlog. It's fair to say the Commission increased the number of days that it sat quite dramatically. In its very early days, when it didn't have much to do, it was meeting for a week or two in New York, and that was all. After the avalanche of submissions in 2009, it increased to 21 weeks. To be honest, more weeks are needed, and I think the best way to do that would be to pay the commissioners and make them full-time. It seems harsh to me that some commissioners are well remunerated because their governments choose to remunerate them well, and other commissioners receive what their governments can afford, which may be substantially less. I believe very strongly in the notion that if 2 people do the same job of work and they're both equally qualified, they should be paid the same amount. And there's an awful lot of discussion about those issues in a variety of contexts. I think it should be applied to the commissioners, and it would be nice if they were able to work full-time. The meeting of states parties might be a mechanism to do this, where they'd say, well, look, the Commission has a huge backlog, let's do this for the next 2 sessions, next 2 iterations of the Commission, so for the next 10 years, and to bear additional cost and have the next commissioners elected on that basis, so nobody feels left out. The mechanism of the sub-commissions is already being used by the commissions to try to spread the workload around. They divide into nominated sub-commissions upon receipt of a submission, or at least when the submission comes up for consideration. It'll be a while before they get to the ones at the end of the queue. But that is a mechanism that they adopted very quickly to try to address exactly that problem. But it isn't satisfactory that these things will take a long time. I feel sorry for states who put together quite expert teams for their submissions and then look forward to that submission being the subject of active consideration and interaction with the Commission in a decade and a half's time, when it may be that a goodly portion of that team has retired or has moved on to other things in their careers. We can't all be blessed with the extraordinary enthusiasm and longevity of Ambassador Coe, and so it could be anticipated that many states, their teams won't be intact with the knowledge and skills that were there, and that's not appropriate either. So I really think if the states parties were to throw some resources at the Commission for a period, to give it a chance to really get ahead and really move forward, I can't see that would be a bad thing at all. I think it would be very, very good.
Thank you,
Thank
Professor
you.
King.
So
We don't have any questions on the floor for now, Professor.
yeah, so I don't know, I'm in your hands. I know that time is passing. You want to take 1 or 2 questions from the virtual audience?
All right, I can read one question, and it was actually related to the previous question from Mr. Dennis Haynes. It was about increasing the number of commissioners in the CLCS, but that was already touched upon. So a follow-up question is as follows. As a general rule for Professor Kay, if the states have 10 years to submit their submission, should not it be realistic to have the CLCS recommendations within 10 years after submission?
To be honest, I think the commissioners would be in some... I think some of them would retire early, very, very quickly. That would be most unfair. I can understand why you would want them to go as quickly as possible, but to do that, they need to be resourced to be able to go faster. I wouldn't want my presentation to suggest that the commissioners were in any way laggards in their approach. They've set a high bar and they've been very thorough, but we would want them to set a high bar and be very thorough. They're a scientific and technical body. So I don't think the commissioners are the problem. And the convention makes it clear how many commissioners are to be elected and the geographical basis for them doing so. So I don't think it can be easily done that we could add another couple of dozen commissioners and say, right, they'll all be on double time while they're doing it. I think the way to do it is to take the existing commissioners, to resource them appropriately and to give them more time to be able to do that. And I would hope that that would be a mechanism that would do no violence to the convention and could be done within the meeting of states parties if it were to be done.
Thank you very much. We do have one more question from Professor Ronan Long. And may we invite him actually to speak live, if it's possible, as he is also on our slate of panelists for the conference.
Thank you very much. And I won't switch on my camera because of bandwidth. I really enjoyed the papers. Congratulations to Ambassador Coe and the distinguished audience and panelists. And I have a particular question for Professor Kay. Do you think that one of the great strengths of the process of submissions is the potential for joint submissions as well as the potential for partial submissions? Thank you very much.
Look, I think the approach that many states have taken with partial submissions has been very wise, and some have used it with in a very adept fashion. One imagines, for example, that Indonesia would have quite an extensive extended continental shelf, and yet when it lodged its first partial submission, it was the tiniest little piece of shelf that you could ever imagine finding anywhere around its coast. And this was very clever and very well done by Indonesia. And they've subsequently come back with 2 further submissions that are very extensive. So they've demonstrated some forethought about how to use the Commission and operate within the 10-year deadline. I think one of the problems is inadvertently the cause of my own home state's over-enthusiasm at approaching the process originally in the first place. Australia, when it lodged its submission, one was very concerned about the 10-year deadline to the extent that it made the 10-year deadline as it originally stood by 1 day. The Australian submission went in the day before it was due. In classic university student, my work is due tomorrow, I'll hand it in sort of 5 minutes to midnight. But the other thing that Australia did was to make its submission incredibly thorough to an extent where they delivered, and I've heard this from more than one commissioner, and I had some tangential involvement with the submission, so I know this to be true. They delivered a 40-foot long shipping container full of paper that contained the entirety of the submission. And to expect the commissioners to read an entire shipping container stacked from floor to ceiling, and not one of the small ones, we're talking about one of the very long ones, absolutely full of paper, was just extraordinary. And then when recommendations were made, the first state to get a complete tick and complete bill of health was Australia, because the Brazilian and Russian submissions each experienced some hold-ups. And as a result, it set a bar to say to states, you need to be as technically thorough with your submission as possible. You need to give us absolutely every piece of paper that you can possibly find that is relevant. And I'm not sure that was really necessary in the circumstances. And the commissioners, in the interest of thoroughness, have gone and read everything. And so you can imagine, I'm possibly not paid. If I am paid, I may be paid significantly less than the person I'm sitting next to. I'm sitting in a room in New York for perhaps 21 weeks away from my family, and somebody delivers a shipping container to the door and says, here, read this. This is very difficult. To be honest, this is why I have great sympathy for the commissioners, all of the commissioners who have served to date and those who are serving at the moment. Their task is huge, and It's unfortunate that states have decided they have one shot in the locker, so they will be incredibly thorough, because they set a standard which the commissioners themselves feel obliged to meet, and everybody does lots and lots and lots of work, and it takes a long time to do good work. And so we have tremendous delays. And the only solution, I think, is, as I say, to throw more resources at them and give them more opportunity to do so. It's too late to wind back the extensive submissions at this point, and indeed the ones that no doubt will still come.
Thank you. So I don't know if there are any other questions.
No more pending questions from the chat, Professor.
So I think it's time to thank the panelists. And it has been a wonderful panel, which has given us a lot of perspectives about the achievements of the Law of the Sea Convention. But also, I think we've started to discuss about some of the issues which need to be addressed in the future. So I thank the panelists, and I give back the floor to the conveners of the conference. Thank you very much. It was a pleasure.